So my topic is international human rights litigation in U.S. courts. Since 1980, more than 100 civil cases have been filed in U.S. courts based on human rights violations outside the United States. Cases have been brought both against individuals and also against corporations. The corporations have been U.S. corporations and also non-U.S. corporations. And these cases have raised many important legal questions, some of which I will discuss today. I might add that these cases have all been civil cases, or almost all of them. The United States does have criminal human rights statutes, but there are almost never prosecutions under them. And I'd be happy to answer questions about that during the questions period. Now, as I will describe, the history of international human rights litigation in U.S. courts is a particularly American story. The shape that this story has taken has been influenced by American history and also by the characteristics of the American legal system. For me, this is also a somewhat personal story because I've been involved with litigating these cases since I was a law student more than 30 years ago. The story begins with a provision of U.S. law known as the Alien Tort Statute, or ATS. The ATS provides the district court shall have original jurisdiction of any civil action by an alien for a tort only committed in violation of the law of nations or a treaty of the United States. This provision was a very small part of the first Judiciary Act of 1789 that first established the U.S. federal courts shortly after ratification of the U.S. Constitution. It's a provision that gives subject matter jurisdiction to the federal courts, which is necessary. Federal courts don't have jurisdiction over a case unless Congress authorizes it with a statute. You can see just from this text that the statute allows aliens, that is non-U.S. citizens, to bring damages in federal court for violations of treaties or the law of nations, what we would today think of as customary international law, although, as I will describe, the content of the law of nations has changed somewhat in the last 200 plus years. The origins of this provision are obscure, but most scholars think that it originated with an altercation between two French citizens on the streets of Philadelphia, Pennsylvania, in the United States. On May 17, 1784, a French citizen known as the Chevalier de Longchamp threatened the French consul general, Monsieur Marbois, in the French ambassador's home. 2 days later, de Longchamp assaulted Marbois on the streets of Philadelphia. This was a violation of the law of nations for which the United States would be held responsible. The U.S. Continental Congress offered a reward for the capture of de Longchamp, but there was very little else it could do because before the ratification of the U.S. Constitution, most authority over both criminal and civil law belonged to the states. The state of Pennsylvania ultimately convicted de Longchamp of a crime against the law of nations for assaulting the ambassador, or the consul general, I should say, on the theory that the law of nations was part of the common law of the state of Pennsylvania. After the Constitution went into effect, the new federal government had authority over these questions. It soon passed a statute criminalizing assaults on ambassadors, and it included the Alien Tort Statute to provide a civil remedy in situations like this in the future. But this statute was hardly ever used for the first 190 years of its existence. In 1980, a federal court of appeals held that this provision provided jurisdiction over international human rights violations. The case was Filartiga versus Peña-Irala. It was a suit by two Paraguayan citizens who claimed that a member of their family had been tortured to death in Paraguay by a police inspector. That police inspector, Peña-Irala, later came to the United States, and he was sued there in the United States. The Filartiga case held that U.S. courts had subject matter jurisdiction over this case, because the suit was by an alien for a tort, and torture is a violation of modern customary international law. The original defendants in this first wave of alien tort statute suits were all individuals. They were generally former officials of foreign governments. They could be low-level officials, like the police inspector in Philadelphia, or they could be former presidents. The case that I worked on when I was in law school was against a former president of Haiti, Professeur Avril, who had tortured some political opponents when he was in power. He later moved to Florida. The United States has many immigrant communities, and these immigrant communities often include both human rights victims and human rights violators. Several important legal issues were raised in this first wave of suits. First, where did the cause of action or the right to sue come from? The Alien Tort Statute provides jurisdiction to federal courts, but it does not by itself create a right to sue. Congress has created some statutory rights to sue for human rights violations. In 1992, it passed a statute called the Torture Victim Protection Act, which I will come back to. But that statute is limited to claims against individuals, and it only applies to torture and extrajudicial killing. It does not apply to other human rights violations, like genocide or war crimes. A second question is, does the ATS apply to modern customary international law, like human rights violations? Or does it only apply to the kinds of violations of the law of nations that the first Congress knew about, like assaults on ambassadors? Third, a private international law question: what law should a U.S. court use to decide these cases? Should it apply customary international law directly? Should it apply U.S. law? Should it apply the law of the place where the tort occurred, which would be the normal private international law solution to this question? Fourth, are these officials entitled to any immunity from suit? Can they claim immunity under the U.S. Foreign Sovereign Immunities Act, which governs the immunities of foreign states? Or can they claim immunity under customary international law or federal common law? These immunity questions really were not raised by defendants until the 2000s, but they're very important in human rights litigation today. There was a second wave of human rights suits against corporations that began in the 1990s, and one of the first suits was Doe versus Unocal. The defendants in this case were the U.S. oil company Unocal and the French oil company Total. These companies were alleged to have aided and abetted human rights violations by the Myanmar military, which was providing security for a natural gas pipeline that these companies were building in Myanmar. The district court dismissed the claims against Total for lack of personal jurisdiction. But the Court of Appeals held that the American company Unocal could be sued for aiding and abetting human rights violations. In terms of the applicable law, the court applied customary international law directly. And it held that under customary international law, a defendant could be held liable for aiding and abetting if it provided substantial assistance to the violation with knowledge of the violation. The case never went to trial, however, because Unocal decided to settle the suit for several $1 million. The second wave of suits has raised additional legal questions. One is whether the customary international law of human rights applies to corporations at all. Recall that following World War II, the Nuremberg tribunals tried only individuals, not corporations, for crimes. The jurisdiction of the International Criminal Court is also limited to natural persons and does not include juridical entities. So does this mean that international human rights norms simply don't apply to corporations? I'll come back to that question. A second question was whether the ATS could be used to sue non-US corporations. And a third question was aiding and abetting liability. Is it a valid claim? And if it is a valid claim, what's the standard of liability? Does it require simply knowledge on the part of the defendant about the violation, or does it require a purpose to facilitate the violation, which would be a higher standard? And aiding and abetting liability is a particularly important question for corporations, because corporations rarely engage in human rights violations directly. More often, they provide assistance to governments who engage in the violations. I might qualify that. They participate in some human rights violations, like slavery or forced labor directly. But usually, corporations are not the ones torturing people or killing them. Okay. The U.S. Supreme Court did not decide an Alien Tort Statute case until 2004. In Sosa versus Alvarez-Machain, a Mexican doctor had been kidnapped from Mexico by Mexican citizens at the request of the U.S. government. The doctor was alleged to have participated in the murder of a U.S. Drug Enforcement Agency official. He was brought to the United States illegally and charged with this crime. The criminal action against him was ultimately dismissed, and he then sued the U.S. government and his Mexican kidnappers in U.S. court. He argued that he had been subject to an arbitrary detention in violation of international law. The Supreme Court held that the United States was immune from suit, but that human rights claims could be brought under this Alien Tort Statute. The main two questions in Sosa versus Alvarez-Machain were the first two that I mentioned, which I have up on the slide. Where does the right to sue or cause of action come from? And second, does the Alien Tort Statute cover modern violations of the law of nations like human rights? Some U.S. judges had reasoned that the statute is purely jurisdictional, and so Congress had to create a statutory cause of action before anyone could bring a suit. I wrote an amicus brief in this case on behalf of professors of legal history that argued that the first Congress that passed the Alien Tort Statute would have understood that the law of nations at the time was part of the common law of the United States, and that the common law would provide the cause of action for bringing these suits. In the United States, if you want to bring a common law claim, a contract claim, or a tort claim, you don't need a statute to bring that claim. The common law itself provides the right to sue. Our argument was that that's what the first Congress expected for suits brought under the Alien Tort Statute too. The Supreme Court, to my amazement, accepted our argument and agreed, and even cited our brief, and held that the cause of action comes from the common law. But there's a problem that has to do with the U.S. legal system, which is that today, common law in the United States is almost entirely state law, not federal law. The common law of contracts, the common law of torts in California is all California law. There's no federal common law of contracts or torts. So what do we do under a statute like this? Well, the Supreme Court decided to create a federal common law cause of action for suits brought under the statute. So let's see, where does the cause of action come from? Federal common law. The Supreme Court also extended the ATS cause of action to violations of modern customary international law, like human rights law. Modern human rights law obviously did not exist in the 18th century. It was created after the Second World War. But as I've shown in some of my scholarship, the people who wrote the Alien Tort Statute understood that the law of nations had changed in the past and that it would continue to change in the future. They could have written a statute that was limited to assaults on ambassadors. It's easy enough to write assaults on ambassadors into the text of a statute. They didn't do that. They drafted it more generally in terms of torts in violation of the law of nations, something they knew could evolve. So I think that Sosa is correct on this point. But Sosa also imposed a limit on the cause of action, that the human rights norms must be as well established as assaults on ambassadors were in the 18th century, that they have to be as well established as what the first Congress thought about at the time. What about the third question? What law applies? Early decisions generally applied customary international law of human rights directly. In the process, they articulated the elements of many of these violations, like torture, extrajudicial killing, genocide, and war crimes. These decisions did not apply the law of the place where the tort occurred. They did not apply Paraguayan law, or Haitian law, or Myanmar law. Applying international law was seen as a way of treating these human rights violations more seriously. They were not just ordinary domestic torts. They were more consequential than that. Sosa, however, suggested another possibility, the idea of creating federal common law to apply in ATS cases. And many human rights advocates started to argue in favor of this, particularly for aiding and abetting, where they thought the law was unclear. I saw this as a very dangerous development. Customary international law is, of course, universal. It applies everywhere. It applies equally in Myanmar and in the United States. But the more U.S. courts started to create federal law and apply federal law to these cases, the more these cases started to look like an illegitimate extraterritorial application of U.S. law. With respect to foreign official immunity, this began to arise shortly after the Sosa decision. In some of the early cases, the issue just was not raised. And when it was raised, new governments often waived the immunity of their former officials. For example, Haiti waived the immunity of former President Avril. The Philippines waived the immunity of former President Marcos when he was sued. We may soon have a new President Marcos in the Philippines. But then some suits were brought against Israeli officials for human rights violations against Palestinians, and as I'm sure you can guess, Israel did not waive the immunity of its officials from suit. The officials argued that they had acted in an official capacity and that were therefore immune. In 2010, the U.S. Supreme Court held in Samantar versus Yusuf that the U.S. Foreign Sovereign Immunities Act does not apply to foreign officials, whose immunity is instead governed by federal common law. But the court did not provide guidance about what the rules of federal common law are for foreign official immunity, or whether it is up to the State Department or the courts to make these rules. The question of corporate liability under the Alien Tort Statute has been before the U.S. Supreme Court 3 times in the last decade, and it still remains unresolved. In 2010, the U.S. Court of Appeals for the Second Circuit held that corporations could never be sued under the ATS because customary international law had not recognized a norm of corporate liability that was sufficiently well established to meet SOSA's requirements. In Kiobel, the plaintiff alleged that Royal Dutch Petroleum had aided and abetted the extrajudicial killing of activists who were opposed to oil drilling in the Niger Delta. Note that this case was against a foreign company as a defendant for conduct that occurred entirely outside the United States. The Second Circuit, in reaching this decision, pointed to the fact that the Nuremberg tribunals had only tried natural persons, not corporations. It also pointed to the fact that the International Criminal Court was, someone's entered the waiting room, I should admit them, I guess. That the International Criminal Court, its jurisdiction is limited to natural persons. In my view, in doing this, the court confused 2 different questions. The court confused the applicability of human rights norms with the jurisdiction of specific tribunals. Customary international law establishes norms of conduct for certain persons. It prohibits torture, for example. But customary international law does not provide for its own enforcement. It does not dictate to states how those norms should be enforced in their domestic legal systems or otherwise. And states have adopted a variety of techniques to enforce these norms. So states have sometimes come together and created international tribunals, like the International Criminal Court. They have sometimes agreed by treaty to prosecute these violations in their domestic courts. You can think of the Convention Against Torture as an example of this, or any of the suppression conventions. And sometimes states decide to act independently and create civil or criminal liability in their own legal systems. It is a mistake, I think. Well, I should say it's a legitimate question to ask whether the prohibition against torture applies to corporations. But the limits that we find on particular tribunals have absolutely nothing to say about that question. A norm of human rights could apply to corporations, and yet a decision might be made to limit the jurisdiction of a particular tribunal only to natural persons. A limit on jurisdiction is not a limit on substantive law. Jurisdiction and substantive law are separate things, and a limit on one does not necessarily imply a limit on the other. When the Kiobel case reached the U.S. Supreme Court, the U.S. government filed a brief arguing that corporations could be sued under the Alien Tort Statute, and that human rights norms like torture, extrajudicial killing, and genocide apply equally to corporations and to natural persons, making some of the points that I've just made. At this time, I had taken a leave from my academic position, and I was actually working at the State Department in the legal advisor's office, so I had a chance to work on this brief, which is the way I developed some of these thoughts. But the Supreme Court in Kiobel did not answer the corporate liability question. Instead, the court applied the so-called presumption against extraterritoriality to the ATS cause of action. Because the defendant was a foreign company that acted entirely outside the United States, the court held that this case did not touch and concern the United States sufficiently to overcome this presumption. The court tried again in 2018 to answer the question in Gessner versus Arab Bank, and it failed again. In Gessner, the victims of terrorist attacks in Israel alleged that Arab Bank, which is a Jordanian corporation, had aided and abetted terrorism by making payments to the families of suicide bombers. Some of those payments went through Arab Bank's branch in New York, so there was arguably enough contact with the United States to meet Kiobel's test, but the Supreme Court split very badly, and all it could decide is that the ATS cause of action should not apply to foreign corporations, non-U.S. corporations, like Arab Bank. The court's most recent attempt to answer this question was only last year in Nestle USA versus Doe. In this case, the defendants were U.S. corporations not protected by the Gessner decision. And the defendants were alleged to have aided and abetted child slavery on cocoa farms in Côte d'Ivoire by providing technical and financial assistance to farms that used child slaves trafficked from Mali. The Supreme Court again applied the presumption against extraterritoriality, as in Kiobel, and it held that there was just not enough conduct in the United States to overcome that presumption. The U.S. companies had engaged in decision-making in the United States, but general decision-making, the court said, was not enough. In other words, I think Nestle requires substantial conduct in the United States. 5 justices in Nestle did agree, finally, that the ATS cause of action should apply to corporations as well as individuals. But this was really a very hollow victory, because non-U.S. corporations are already excluded by Gessner from the ATS cause of action, and U.S. corporations have to engage in some conduct that goes beyond decision-making, which they hardly ever do. I think the decision in Nestle even threatens to end the ATS cases against individuals, like the original Filartiga case. In these cases, the conduct occurs entirely abroad. In Filartiga, the torture and murder of the Filartigas son and was entirely in Paraguay. The only U.S. connection is that the defendant later came to the United States and so was subject to personal jurisdiction in the United States. So we now have answers to a few more of these questions. Does human rights law apply to corporations? Probably yes, according to the U.S. Supreme Court at least. Does the ATS apply to non-U.S. corporations? Jessner says no. And is there aiding and abetting liability? The Supreme Court has not addressed this question. U.S. lower courts have said yes, but they are split on the standard. Some say that it's enough for the corporation to have acted with knowledge of the violations. Others say that the corporation has to have acted with a purpose of providing substantial assistance. So what we see in these cases, these four U.S. Supreme Court cases involving the Alien Tort Statute, is an initial willingness to recognize the possibility of human rights claims, but then a repeated attempt to limit the cause of action until I think there is almost nothing left of the ATS cause of action. So are there any other possibilities for bringing human rights cases in U.S. courts? I've mentioned one already, which is the U.S. Torture Victim Protection Act. In 1992, Congress passed this statute to provide an express cause of action for torture and extrajudicial killing under color of foreign law. This was at a time when whether an express cause of action was required or not was unclear. The TVPA refers to torture and extrajudicial killing under color of foreign law, which is a clear indication that the statute does apply extraterritorially. But the TVPA is limited to suits against individuals, which the Supreme Court held in 2012 does not include legal entities like corporations. With respect to suits against individuals, the main obstacle has been foreign official immunity. Under customary international law, heads of state, heads of government, and foreign ministers are entitled to absolute immunity from suit in the courts of other countries while they remain in office. Other officials and all former officials are entitled to immunity only with respect to actions taken in their official capacities. The second kind of immunity is often called conduct-based immunity because it depends on the character of the official's conduct. In an article that I published last year with Professor Keitner, I argued that conduct-based immunity does not apply to serious human rights violations because there is no general and consistent practice of states of providing such immunity. Some courts have granted such immunity. In fact, French courts have tended to grant such immunity. But other courts have denied this immunity. And under customary international law, we require a general practice of states and opinio juris to establish a rule. If we have mixed practice, there simply can't be such a rule. Now, I've mentioned already that foreign official immunity in the United States is governed by federal common law. So one question then is, how does this customary international law relate to federal common law? These questions are still contested, but I will give you my view of what the law should be. The State Department claims that it is entitled to make the rules of foreign official immunity. I think that's wrong, and Professor Keitner and I said so in our article last year. In the United States, the executive branch of government has no authority to make law unless it is given that authority by Congress. And in this case, there's no grant of authority to make this kind of law. So in my view, it's up to courts to decide what the rules of foreign official immunity are. And Professor Keitner and I have argued that that immunity should not extend beyond what customary international law requires. The U.S. Supreme Court has said that courts should be cautious about making customary international law, and we think that's particularly true when these rules might frustrate the application of statutes that Congress has passed, like the Torture Victim Protection Act. I will mention just one other statute, before moving on to some more general observations. Congress has passed something called the Trafficking Victim Protection Reauthorization Act, or TVPRA. We put the R in to distinguish it from that other statute. And in 2003, Congress created a civil cause of action for victims of slavery, forced labor, and human trafficking. The cause of action is very broad. It applies to the perpetrator and any other person who knowingly benefits from that conduct. The TVPRA clearly does apply to corporations, and there's no question of foreign official immunity because corporations are not foreign officials and are not entitled to such immunity. But unfortunately, there is a question of extraterritoriality. Congress has amended the statute in 2008 to apply extraterritorially, but when it did so, it only mentioned the criminal provisions of the act, not the civil cause of action. And at least one court has held in a suit against Apple, the people who made my nice computer here, that the cause of action does not apply extraterritorially to, in that case, children who were injured mining cobalt in Democratic Republic of the Congo. Okay, so I'm going to conclude in just a few minutes here. So I said at the beginning that this story is a particularly American story. So what do I mean? First, the Alien Tort Statute is unique. There's no other country I know that has a statute that allows people to sue for torts in violation of the law of nations. It was enacted many, many years ago when the world was very, very different, and in fact, international law was different. It was enacted to allow people like Monsieur Marbois to bring their claims against the Chevalier de Longchamp if he wanted to. It's important to remember that at that time, the United States was very concerned with obeying international law. The United States was a small, weak country that was subject to intimidation by larger, stronger countries like France. And violating the law of nations at that time was a just cause for war. France could have gone to war with the United States if it wanted to, lawfully, for not protecting its consul general. The United States is also unusual in applying customary international law directly to human rights violations. The basic idea for this is that customary international law is part of common law. This is an idea that goes back to England in the 18th century. But the United States is almost unique in doing this. It's not unique, however, because in 2020, the Canadian Supreme Court, in a case called Nevson, held that customary international law is part of Canadian law and that a Canadian corporation could be sued for human rights violations in Eritrea. Other common law countries, like the United Kingdom, in cases like this, apply their domestic law. They do not apply customary international law directly. Third, one thing that makes this area distinct is the role of federal common law. The recognition of a federal common law cause of action in SOSA and then its narrowing in Kiobel, Jessner, and Nestle reflect the federal character of the U.S. legal system. As I said, in the United States, common law is generally state law. Federal law is very rare. It's not supposed to be used very much. And so the fact that this was a federal common law cause of action in part led to its progressive narrowing in later cases. And last, and perhaps most obviously, international human rights litigation in the United States depends on litigation as a way of protecting international human rights. When Congress has passed additional statutes, it has also relied on litigation. The Torture Victim Protection Act and the Trafficking Victim Protection Reauthorization Act both create causes of action that allow private parties to sue. That's the way the United States has chosen to address human rights violations, primarily. This is a very different approach from the approach in France, where under the 2017 La Loi relative au devoir de vigilance, for example, French companies are required to make a plan and implement the plan to prevent a human rights violation. Americans are often viewed as very litigious, as thinking that every social problem can be solved by filing a lawsuit. And there is some truth in that characterization of Americans. There's a long history of solving social problems by filing lawsuits, like the desegregation of US schools during the 1950s and 60s. Modern human rights litigation has modeled itself on that, I think, without really thinking about other possibilities. Litigation has the advantage of compensating victims, but it also has some disadvantages, and I'd like very briefly to turn to some of the limits, in conclusion, to turn to some of the limits of litigation. So first, as I've mentioned, are the limits on the causes of action. There's almost nothing left of the ATS cause of action. The TVPA is limited to suits against individuals. It does not apply to corporations. The TVPRA does apply to corporations, but it is limited to slavery, forced labor, and human trafficking. For suits against corporations, there are also problems of personal jurisdiction. U.S. corporations are subject to personal jurisdiction in the United States, but foreign corporations are not unless the cause of action arises out of their contacts with the United States. When U.S. companies operate abroad, they usually do so through a foreign subsidiary. It is usually not the parent company that engages in the human rights violation. It's usually the subsidiary. The subsidiary can't be sued in U.S. court. The parent company can, but the parent company hasn't done anything wrong because it's the subsidiary that has taken the action. And in general, there's no duty on the parent company under U.S. corporate law to supervise the subsidiary. Also, under U.S. law, there has to be personal jurisdiction over each defendant. You can't, just because you have jurisdiction over the parent, that doesn't mean, like you can under the Brussels I regulation, bring in co-defendants in related cases. Litigation, as I mentioned, may be able to compensate victims, but I think it has a very weak deterrent effect. The risk of liability from one of these cases, it's almost being held liable in one of these cases, it's almost like being struck by lightning. It's so unusual that it has a very weak deterrent effect. And just like you would still go out in the rain even if there's lightning over, corporations still go about their business overseas. In my view, an approach like the law relative to the duty of vigilance may be a better approach. It has the advantage not only of potentially providing compensation. I know there are private international law problems with those suits, but more fundamentally, it has the possibility of preventing the human rights violations before they occur, which strikes me as a much better approach to human rights, and one the United States really has yet to try. With that, let me end, and I look forward to your comments and your questions. And I'm sorry I've gone on so long.
Thank you.